Imagine waking up to the sound of shouting outside your window. You peer through the shutters to see your neighbors dragging a man through the muddy street, his hands bound, his face bloodied. There's no trial, no lawyer, no judge in robes deliberating over evidence. Just a rope, a tree, and a crowd hungry for what they call justice. By sunset, that man will be dead, not because a court convicted him, but because your community decided he deserved to die. This wasn't a scene from a lawless frontier or a Hollywood Western. This was reality for countless communities in colonial America and the early United States. In the absence of established police forces, professional judges, or standardized legal procedures, ordinary townspeople became the entire justice system. They investigated crimes, determined guilt, passed sentences, and carried out punishments, including execution, all within hours or days, sometimes with nothing more than rumor and rage as their guide. Today, we're diving deep into one of the darkest and most complex chapters of American history, the era when communities became their own courts of law, when mob rule masqueraded as justice, and when the line between righteous punishment and murder became terrifyingly thin. What drove ordinary people to take the law into their own hands? How did these community tribunals operate? And what does this brutal history teach us about justice, power, and human nature? The answers are as disturbing as they are enlightening. To understand why communities became their own judicial systems, we must first grasp the profound absence of formal law enforcement and legal infrastructure in early America. Between the 1600s and the mid-1800s, the American colonies and early United States existed in what we might call a legal wilderness. Vast territories with minimal governmental authority and virtually no professional law enforcement. The English common law system that theoretically governed the colonies was designed for a compact, settled society with established courts, trained magistrates, and reliable communication networks. America had none of these. Settlements were scattered across enormous distances, separated by days or weeks of difficult travel. A colonial village in western Pennsylvania might be 200 miles from the nearest courthouse, with nothing but forest, mountains, and hostile territory in between. For most colonists, the formal justice system was effectively inaccessible. The few law enforcement positions that did exist, constables, sheriffs, and marshals, were woefully inadequate. These were typically part-time positions held by ordinary citizens serving brief terms, often reluctantly. A constable might be a farmer, blacksmith, or shopkeeper with no legal training, no backup, and limited authority beyond his immediate community. Sheriffs, while more permanent, were primarily tax collectors and court officers, not criminal investigators. They had no forensic tools, no communication systems, and no means of pursuing criminals who simply fled to the next county or colony. The court system was equally primitive. Circuit judges might visit a settlement once or twice a year, creating enormous backlogs of cases. Jails were rare and primitive, often just a single room in someone's home or a crude wooden structure that anyone determined enough could escape from. Holding a prisoner for months while awaiting trial was impractical, expensive, and dangerous. Communities needed faster solutions. This institutional vacuum coincided with a harsh, often violent environment. The colonial and frontier experience was defined by constant threats, indigenous resistance to settlement expansion, disputes over land and resources, livestock theft, boundary disagreements, and the ordinary crimes of theft, assault, and murder. In a world where your nearest neighbor might be miles away and help could take days to arrive, self-reliance wasn't just a virtue, it was a survival necessity. Religious and cultural factors also shaped community justice. Puritan communities in New England operated under theocratic principles, where religious leaders wielded enormous authority and sin and crime were often indistinguishable. Southern colonies, with their plantation economies and enslaved labor forces, developed brutal systems of control where slave owners and overseers held near absolute power over the enslaved population. Frontier communities attracted risk-takers, outcasts, and people fleeing established society, populations with limited faith in distant authorities and strong beliefs in direct action. The result was a hodgepodge of informal justice systems where communities simply took matters into their own hands. These weren't necessarily lawless societies in the sense of having no rules. Rather, they created their own extralegal systems based on local customs, religious beliefs, economic interests, and the raw exercise of collective power. When a crime occurred, the community response was immediate, direct, and often brutal. This system of community-based justice had deep roots in English and European traditions of collective enforcement, the hue and cry, where citizens were obligated to pursue criminals, the posse comitatus, where sheriffs could compel citizens to assist in law enforcement, and the tradition of community consensus in determining appropriate punishments. But in the American context, these traditions mutated into something far more uncontrolled and dangerous. Without professional oversight, written procedures, or appellate review, community justice could rapidly degenerate into mob violence, where personal vendettas, racial prejudice, economic interests, and sheer sadism masqueraded as legitimate punishment. The stage was set for some of the most disturbing episodes in American legal history, moments when ordinary people, convinced they were upholding justice and protecting their communities, became killers operating under the thinnest veneer of legitimacy. In the back country of South Carolina during the 1760s, a full-scale vigilante movement emerged that perfectly illustrates how communities became their own judicial systems. The region between Charleston and the Appalachian frontier was experiencing rapid settlement, but had virtually no governmental presence. The colonial assembly, dominated by coastal planters, provided no courts, no sheriffs, and no jails for the interior settlements. Into this vacuum came bands of outlaws who terrorized the backcountry with impunity. Horse theft, robbery, assault, and murder became commonplace. Victims had no recourse. The nearest court was in Charleston, over 100 miles away through difficult terrain, and criminals simply melted into the wilderness after their crimes. The situation became intolerable. In 1767, respectable settlers organized themselves into groups called regulators, vigilantes who would regulate behavior through direct action. These weren't ragtag mobs but organized movements led by prominent landowners, militia officers, and community leaders. They created their own legal code, investigation procedures, trial processes, and punishment systems. When the regulators suspected someone of criminal activity, they would form a search party, apprehend the suspect, and bring them before an assembly of regulators for trial. These proceedings had the form of legal trials. Accusations were stated, evidence presented, and the accused could offer a defense, but they lacked any legal authority. The regulators themselves served as prosecutors, judges, and jury. Punishments were swift and often brutal. The regulators' favorite penalty was public whipping, typically 39 lashes administered while the victim was tied to a tree or post. For more serious offenses, they employed Moses' law, referring to the biblical limit of 40 lashes, though they often exceeded this. Victims were sometimes required to leave the colony entirely, essentially banishment enforced through threat of death if they returned. In extreme cases, the regulators conducted executions, hanging those they deemed irredeemable. One documented case involved a man accused of horse theft, a serious crime in an agrarian society where horses were essential for survival and valuable property. The regulators apprehended him, conducted a hasty trial where several witnesses claimed to have seen him with stolen horses, found him guilty, and hanged him from a tree that same afternoon. His body was left hanging for days as a warning. No formal legal authority ever reviewed the case. Years later, evidence emerged suggesting he may have been innocent, having purchased the horses legally from someone who had stolen them. The regulators operated for nearly 3 years, inflicting hundreds of whippings and conducting numerous executions. They maintained detailed written records of their proceedings, presented themselves as upholders of order rather than lawless vigilantes, and genuinely believed they were providing necessary justice in the absence of governmental authority. Many respectable citizens supported them, seeing the regulators as the only defense against criminal chaos. The movement only ended when the colonial assembly finally established courts in the backcountry in 1769, providing a formal legal alternative. Many former regulators became sheriffs, constables, and magistrates in the new system, their vigilante credentials viewed as proof of their commitment to order. The transition from extralegal vigilantism to legitimate law enforcement was seamless, revealing how thin the line between the two actually was. The Civil War created conditions where community justice could turn genocidal. In January 1863, in the mountains of North Carolina, a Confederate officer named Lieutenant Colonel James Keith led an expedition into Shelton Laurel, a community known for Union sympathies in predominantly Confederate Madison County. Keith's mission was to punish the community for a raid on the county seat where salt, a crucial wartime commodity, had been seized by Union sympathizers. Keith's troops rounded up elderly men, women, and children, interrogating them about the raiders' identities. When they refused to provide information, Keith selected 13 males from the community, the youngest just 13 years old, the oldest in his 60s, none of whom had participated in the raid. Without any form of trial, without evidence connecting them to any specific crime, Keith ordered his soldiers to execute them all as a lesson to the community. The victims were forced to kneel in the snow, and soldiers systematically shot them in the back of the head. When the first volley failed to kill all the victims, Keith personally ordered his men to finish the wounded with additional shots. The bodies were left in a ravine, where they were later discovered by horrified community members. This wasn't a spontaneous mob action, but a calculated act of terror carried out by military authority acting as judge, jury, and executioner. Keith justified the massacre as necessary wartime discipline against traitors and guerrillas. The Madison County community supporting the Confederacy largely approved, viewing the killings as legitimate punishment for disloyalty. It was community-sanctioned execution, just with the community divided along political and military lines. The legal aftermath is telling. After the war, Keith was briefly arrested but never prosecuted. North Carolina authorities, unwilling to punish Confederate veterans, dropped the investigation. The community never received justice through formal legal channels. The Shelton Laurel massacre demonstrates how community-based justice can become mass murder when political divisions, wartime conditions, and the absence of neutral legal authority combine. Perhaps the most famous examples of community justice in American history were the San Francisco Vigilance Committees, organized vigilante movements that took over the city's government twice in the 1850s, conducting their own arrests, trials, and executions. The California Gold Rush transformed San Francisco from a sleepy settlement to a chaotic boomtown virtually overnight. The city's population exploded from under 1,000 in 1848 to over 35,000 by 1850. With inadequate governmental infrastructure to maintain order. The city attracted not just prospectors but also criminals fleeing justice elsewhere, creating a crime wave that overwhelmed the small police force and corrupt judicial system. In 1851, after a series of fires, some deliberately set, robberies and murders, prominent merchants and businessmen formed the Committee of Vigilance. They created an organization with over 700 members, established headquarters at a fortified building they called Fort Gunnybags, and began arresting suspected criminals. The Vigilance Committee operated like a parallel government. They issued their own warrants, maintained their own jail, conducted their own trials, and carried out their own sentences. The trials had elaborate procedures. Prosecutors presented evidence. Defendants could call witnesses and offer defenses, and a jury of committee members determined guilt. But there was no legal authority behind any of it. The committee simply asserted power through numbers and organization. Between June and September 1851, the committee tried dozens of suspects. 4 men were hanged, others were whipped or banished from the city. The most famous case involved John Jenkins, an Australian immigrant accused of stealing a safe. He was arrested by the committee at night, tried within hours before a hastily assembled tribunal, found guilty, and hanged from a building beam, all before dawn. When legitimate legal authorities attempted to intervene, committee members blocked them at gunpoint. The entire process from arrest to execution took less than 6 hours. The 1856 committee was even more powerful. Following the murder of a newspaper editor, a reconstituted vigilance committee of over 8,000 members essentially took over San Francisco's government for 3 months. They arrested dozens of people, conducted elaborate public trials in their headquarters, hanged 4 men, and forcibly exiled dozens more by putting them on ships leaving California. The committee even engaged in military operations, seizing the county jail, confronting state militia units, and creating a de facto independent government. What makes the San Francisco Vigilance Committees particularly significant is their self-awareness and organization. These weren't spontaneous mobs but carefully structured organizations with bylaws, membership roles, and procedural rules. They genuinely believed they were providing legitimate justice that the corrupt official system had failed to deliver. Many committee members were respected citizens, merchants, professionals, community leaders, who saw themselves as reformers, not lawbreakers. The committees dissolved voluntarily once they believed order was restored, with many members subsequently elected to official governmental positions. The vigilante justice they dispensed was later romanticized as heroic. San Francisco still has streets named after committee leaders, demonstrating how community justice can be retconned into legitimate history when the victors write the narrative. While most examples of community justice occurred in the chaos of the frontier or Civil War, the case of Leo Frank demonstrates that such practices persisted well into the 20th century, even in civilized settings. In 1913, Mary Fagan, a 13-year-old factory worker, was murdered in Atlanta, Georgia. Leo Frank, the factory superintendent and a Jewish northerner living in the South, was arrested and charged with the crime. The evidence against Frank was weak and contradictory, but anti-Semitic prejudice and regional resentment ran high. After a sensationalized trial marked by mob intimidation and judicial irregularities, Frank was convicted and sentenced to death. When the Georgia governor, after reviewing the evidence, commuted Frank's sentence to life imprisonment, essentially acknowledging the trial had been unjust, public outrage exploded. A group of prominent citizens from Marietta, Mary Fagan's hometown, formed a group they called the Knights of Mary Fagan. This wasn't a random mob but an organized group including a former governor, judges, lawyers, and other respectable community leaders. On August 16, 1915, 25 Knights traveled to the state prison, overpowered the guards, and kidnapped Leo Frank. They transported him 175 miles to Marietta, where they conducted their own trial, allowing Frank to make a statement proclaiming his innocence before unanimously finding him guilty. They then hanged him from a tree near Mary Fagan's childhood home. The lynching was treated as community justice. Thousands of Marietta residents came to view Frank's body, which was left hanging for hours. Photos of the lynching were sold as postcards. Not a single participant was ever prosecuted, despite detailed knowledge of their identities. The community broadly approved, viewing the lynching as correcting the governor's improper interference with their verdict. The Leo Frank case reveals how community justice persisted in the 20th century and how it could be driven by prejudice, revenge, and mob mentality while being celebrated as righteous punishment. The community became judge, jury, and executioner, with the full support of local society. The practice of communities serving as their own judicial systems created profound and lasting impacts on American society, shaping attitudes toward law, authority, and justice that persist today. When communities regularly bypassed formal legal systems, it fundamentally undermined the concept of rule of law. Why wait months for a circuit judge when the community could decide guilt and administer punishment immediately? Why respect legal procedures when they seemed like obstacles to real justice? This attitude bred contempt for legal formalities that were actually designed to protect against wrongful convictions. The absence of due process protections, right to counsel, presumption of innocence, burden of proof, appellate review, meant that community justice was often profoundly unjust. People were convicted on rumor, circumstantial evidence, or outright lies. The powerless, racial minorities, outsiders, the poor, had no protection against community prejudice. Once a community decided someone was guilty, no amount of evidence to the contrary mattered. The system couldn't self-correct because there was no appeal to a higher, more neutral authority. Community justice inevitably reflected community power structures, who got to serve on vigilante committees, who got to vote on guilt or innocence. Always the property, the established, the locally powerful, never the marginalized. This meant that community justice systematically protected certain groups while victimizing others. In the South, community justice was a tool of racial control. Enslaved people had no access to legal protection. Their owners served as prosecutor, judge, and executioner for any alleged misdeed. After emancipation, lynching became the primary form of community justice applied to African Americans, with over 4,000 documented lynchings between 1877 and 1950. These weren't random acts of violence but community-sanctioned executions, often performed publicly with broad participation and approval. Similarly, indigenous people, Mexican Americans, Chinese immigrants, and other marginalized groups faced community justice that was really just vigilante terror. When a Chinese miner was accused of crime in a California gold rush town, he had no realistic chance of fair treatment from a community tribunal composed entirely of white miners who resented Chinese competition. Community justice didn't end conflicts, it perpetuated them. When one community executed someone from another clan, family, or ethnic group, it triggered retaliation. The infamous Hatfield-McCoy feud exemplifies how community-based justice could spiral into multi-generational violence. Each killing was justified as legitimate punishment for previous wrongs, creating an endless cycle that formal legal systems were designed to interrupt by providing neutral arbitration. Participating in community justice, especially executions, had profound psychological effects. Forcing ordinary citizens to become executioners normalized violence and desensitized communities to brutality. When your neighbor helped hang someone, when the town minister blessed a whipping, when children were brought to witness public punishments as moral lessons, it created a culture where violence was embedded in the social fabric. Yet this also created cognitive dissonance. Most participants genuinely believed they were good people doing necessary work, not murderers or torturers. This required psychological justifications, dehumanizing victims, exaggerating their crimes, emphasizing community protection. These same psychological mechanisms enable ordinary people to participate in atrocities throughout history. Perhaps the most damaging legacy was the establishment of a cultural pattern where communities felt entitled to override formal legal systems whenever those systems produced results they disagreed with. This attitude, that community sentiment trumps legal procedure, echoes through American history in everything from nullification crises to modern jury nullification debates. The transition to professional law enforcement and formal judicial systems required not just building institutions, but changing deeply embedded cultural attitudes. Communities had to learn to trust distant authorities, accept that justice delayed might be justice preserved, and understand that legal formalities served essential purposes. This transition was slow, incomplete, and remains contested in some quarters even today. The era when townspeople served as judge, jury, and executioner might seem like distant history, but its echoes resonate powerfully in contemporary American society. Understanding these connections helps us grapple with ongoing debates about justice, community, and the proper role of formal legal systems. Modern stand-your-ground laws, which remove the duty to retreat before using deadly force, essentially grant individuals the power to serve as judge, jury, and executioner in situations they perceive as threatening. The controversial shootings of Trayvon Martin, Jordan Davis, and others demonstrate how these laws can replicate the dynamics of historical community justice, where the shooter's perception of threat, often shaped by racial prejudice, becomes the only relevant factor, and formal legal review is minimal. Like historical community justice, these laws disproportionately harm racial minorities. Studies show that white shooters claiming stand-your-ground defenses against black victims are far more likely to be exonerated than the reverse. The same pattern we see in historical vigilante justice, where community prejudices determined outcomes. The modern epidemic of police violence represents a disturbing echo of community justice. When police officers kill suspects without trial, even when the victims are unarmed, fleeing, or complying, and face minimal accountability, they're functioning as judge, jury, and executioner. The community may not directly participate, but when communities excuse or celebrate such killings, they're endorsing the same principle, that certain people's guilt can be assumed and punishment administered without legal process. The parallel is most stark in cases where police killings are defended based on community safety or the victim's alleged past behavior, the same justifications vigilantes used. He was a threat to the community, or he had a criminal record, functioned as community justice in the 1800s and functions as justification for extrajudicial police killings today. Modern community policing movements and neighborhood watch programs try to recreate positive aspects of community involvement in public safety while avoiding vigilante violence. But the tension is real. The killing of Ahmaud Arbery by neighborhood vigilantes in Georgia in 2020 demonstrated how quickly community protection can become vigilante violence when residents appoint themselves as law enforcement. The challenge is striking the balance that eluded colonial and frontier communities: how to engage community participation in public safety without enabling mob justice. Modern community policing advocates argue this requires professional oversight, clear legal boundaries, and strong accountability mechanisms, all the things historical community justice lacked. Perhaps the most direct modern parallel is social media mob justice, where online communities identify, judge, and punish alleged wrongdoers without legal process. Doxing, publishing personal information, coordinated harassment campaigns, and efforts to get people fired or socially ostracized based on alleged misconduct are 21st century versions of community-imposed punishment. Like historical community justice, social media mobs often get facts wrong, rush to judgment, ignore context, and impose punishments disproportionate to offenses. And like historical community justice, they target the vulnerable more than the powerful. Ordinary people can be destroyed by online mobs, while celebrities and elites often escape consequences. Current debates about criminal justice reform include calls for greater community involvement in both prosecution and sentencing, community courts, restorative justice programs, and community input into police oversight. These movements try to recapture positive aspects of community justice: local knowledge, proportional responses, reconciliation, while avoiding the negatives: mob rule, prejudice, lack of due process. Restorative justice programs, for example, bring victims, offenders, and community members together to determine appropriate responses to crime, a form of community justice, but with professional facilitation, voluntary participation, and formal legal oversight. This represents an attempt to learn from both the failures and occasional successes of historical community justice. Perhaps most fundamentally, the history of community justice raises questions about institutional trust. Historical communities took law into their own hands because they didn't trust or didn't have access to formal legal institutions. Today, communities with similar distrust, especially communities systematically failed by formal justice systems, face analogous temptations toward informal justice. When marginalized communities don't trust police to protect them or courts to deliver justice, informal systems emerge, whether gang justice in urban areas, vigilantism in rural regions, or online mob justice in digital spaces. The historical lesson is that building legitimate, trustworthy, accessible legal institutions is the only sustainable alternative to community-based mob justice. As we've journeyed through the dark history of community-based justice in America, we've witnessed something both sobering and illuminating: the transformation of ordinary people into executioners, not through individual madness but through collective conviction. The South Carolina Regulators, the Shelton Laurel massacre perpetrators, the San Francisco Vigilance Committees, and the lynchers of Leo Frank all believed they were upholding justice, protecting their communities, and doing necessary work that absent or corrupt authorities had failed to do. This is perhaps the most unsettling lesson. Community justice wasn't usually the work of obvious villains, but of people who saw themselves as heroes. They organized elaborate procedures, kept careful records, and operated in broad daylight with community approval. They created the trappings of legitimacy: trials, witnesses, deliberations, without the substance, neutral judges, due process, or appeals to higher authority. They convinced themselves that community consensus equaled justice. History judges them more harshly. We now recognize that community justice without institutional safeguards inevitably becomes mob justice. It punishes the powerless while protecting the powerful. It amplifies prejudice rather than correcting it. It perpetuates cycles of violence rather than ending them. And it mistakes vengeance for justice, punishment for resolution. The transition from community-based justice to professional legal systems wasn't just institutional evolution. It was moral progress. It represented the recognition that justice requires more than community sentiment. It requires procedures that protect the innocent, even at the cost of occasionally freeing the guilty. It requires neutrality, even when community passions run high. It requires patience, even when swift punishment seems more satisfying. These aren't just technical legal niceties. They're the difference between justice and atrocity. Yet we cannot be entirely self-congratulatory. The formal legal systems we've built have their own profound failures: mass incarceration, racial disparities, police violence, wealth-based justice, where the rich receive different treatment than the poor. And in communities systematically failed by these institutions, the temptation toward informal justice persists. When people don't trust police to protect them or courts to deliver justice, they create their own systems, just as colonial and frontier communities did. The challenge for our time is building legal institutions that combine the strengths of both approaches: the community knowledge, proportionality, and participation of community justice, with the due process, neutrality, and oversight of formal legal systems. This is the promise of restorative justice, community courts, and reformed policing: attempts to engage communities without empowering mobs, to respect local knowledge without enabling prejudice. As you reflect on these stories of community justice, consider: would you have joined the regulators, believing you were protecting your neighbors from criminals? Would you have participated in the San Francisco Vigilance Committee, convinced corrupt officials had abandoned your city to chaos? Would you have approved of Leo Frank's lynching, trusting your community's judgment over a distant governor's? Or would you have stood against the mob, risking ostracism or violence to defend unpopular principles of due process and rule of law? These aren't just historical questions. Every time we hear calls to bypass legal procedures because they're too slow or technical, every time we justify extrajudicial punishment because someone deserved it, every time we trust community sentiment over institutional process, we're grappling with the same tensions that created the horrors we've explored today. We'd love to hear your thoughts. Do you think communities should have more say in how justice is administered, or do formal institutions better protect everyone's rights? Can we recapture positive aspects of community involvement without recreating the dangers of mob justice? How do we build legal systems that are both legitimate to communities and protective of individual rights? Share your reflections in the comments below. If this deep dive into a troubling chapter of American history has made you think differently about justice, community, and power, please like this video and subscribe to our channel for more explorations of historical topics that still matter today. Next time, we'll be examining another often overlooked aspect of American legal history that continues to shape our world. Until then, remember that understanding how our ancestors struggled with justice and often failed is essential to ensuring we do better. The past isn't just prologue, it's warning, lesson, and hopefully, inspiration to build something fairer. Thank you for watching, and we'll see you in the next documentary.